underneath you have a normative claim, and is your target, to make it simpler, is your target Cass Suskins, is your target nudge, or if I react, but I don't want to interrupt. So
no, I'm wondering because this history is of sort of fads and fashions within legal research and the relationship between what philosophy and ideas and functional output of that by government. And I think it's a history that's actually worth saying, because it's very annoying that you sit in meetings of we need new research in this area, and it seems a bit anachronistic because there is so these similarities. I wonder if you just wanted that claim, or if there's a normative claim that we shouldn't be looking at these behavioural outputs and use the law instrumentally.
Well, like precisely, our aim was to bring this historical, the history of the debates on laws of nature, in order to make this contemporary illusion and the rhetorics of new approaches to law. So it's actually that was the aim, and just to. Of course, this is analogy. So this is, of course, the question: to what extent we can understand psychological laws as laws of nature in the same way in which they were understood in early modern times. But I think but we are interested in this function. So why to refer to any kind of regularities, whether they are brought to law through science, whether they are laws of nature understood in this on different way, but what is the function of this, what is the need of the policy makers or lawmakers being informed by the knowledge of nature, whatever represented. So that was the aim, just to show that what is happening now is not new. Although it is presented now, and it's of course very important because it's very, very influential on that how law is actually now designed. Whether there's normative claim, no. I think we are trying just to show, just to understand how these references also may change the way in which we think about law, and we are not saying that we should not think about law in instrumental ways. We are just saying that we are thinking about this way, and actually we are absolutely not like the people applying behavioral science. They don't care at all about validity and normativity, and they treat nature as something to which they should adjust political institution. And it's very we just want to show this move without really saying whether it's good or bad, at least for now. Just to understand what is going on. There, this is the first.
But our audience gets the point.
Yeah.
Not so much a question as a thought which arose thanks to your presentation. It was very stimulating because the description of the historical development you gave made me think about some things that I've encountered in my research which corroborate a lot with your story. And, for example, what you said about the continuity between 18th century ideas of natural law and not really dying out, but finding its continuance in the 19th century. The funny thing is, you mentioned the whole debates on natural law and social contracts and how sort of the constitutional aspect of it. But what I found very funny when I'm looking a lot at criminal qualifications of criminal law at the end of the 18th and early 19th century, and the crimes were not just written down in laws, they are actually given shape as sort of families, as sort of a genealogy, as Linnaeus would do. They seem to have been written as though crimes are something in nature which can be categorized in a similar way as, for example, plants and birds and bees can be. And the funny thing is, this sort of more or less implies that crimes are something in nature. And when you look in the late 19th century, the positive research of, what's the name of this famous Italian researcher in the late 19th century?
Lombroso,
who studied the skulls of criminals to see what are the natural requisites, what are the natural characteristics of criminals. This also implies or presupposes that crimes are something in nature, which are not humanly made up or agreed upon. And I think this changes completely in the 20th century. The approach to crimes becomes, especially from the second half of the 20th century, becomes much more yeah, how to say it, like the behavioral sciences, it's it's approached far more instrumental and not anymore as if crimes are something in nature. So I think that sort of lines up nicely with your story.
Thanks so much. Thank you. Wonderful.
That was one of the questions.
I actually have a question for Tina. Thank you. That was a very interesting presentation on something I don't know very much about. But I'm just wondering about, from what you present, it seems that law in China in these periods is quite a top-down thing. You've got legalists and philosophers. I'm just wondering, sort of, what was the sort of local level of understanding of law? Because presumably the vast majority of people involved in the regulation society weren't scholars or weren't. Was there sort of ideas of customary law or ideas of local assemblies? Or how is that organized?
It's true that law is probably very much top-down because it was a centralized system. So especially in the Qin state and later on in the empires, they had a very emperor-centric law system that has, or administrative system overall. That meant that cases were actually, or problems were actually judged by officials in a court-appointed position. So down to the lowest level, down to the magistrate, which is normally they don't have a separate judge, but the magistrate also judges these kind of cases. And Confucianism is actually customary law. There is no law in the sense, but because it's based on the Li principle, it's the closest to law it comes is customary law. The ideas are actually that there is a few written enforceable laws in Confucianism, but they're only enforceable because they are an expression of. You might compare it to the historical jurisprudence school, the Volksgeist idea, that it's actually an expression of what is right and for the people, for the Han people. So there is actually a lot of enforcement down to the lowest level.
So it is extremely ancient, I think. The transition sort of imperial-centric was very, very, very early before you can really have any sort of record.
Well, they had records. Chinese records go back pretty far. The Hanshu, the Book of Han, is the history of Han, and the Shiji is the history of the kings and the people before that, back to the mysterious emperors that are just mystical figures. So there's actually a lot of record on how it is. Of course, there's always the question how reliable the sources are, but there's evidence that, for example, there's written on both vessels law codes from 500 BC. So there's actually quite a few things, yeah.
Can I ask a question?
Yeah. Sure.
To Hugo, actually, I was wondering, I know nothing about radical pluralism and nothing about McGill, which seems to be the fulcrum of this approach, but my question is, you spoke about internalizing social values. So what role does cultural diversity in societies play in this, the cultural encoded values and the susceptibility to accept values according to the cultural contexts or backgrounds of non-addressees?
I think that's where the pluralism of the theory comes in. When you have a community that is strong enough to create a repetitive number of individuals who have a common internalized value, then you have something legal, a new legal center in your geographic jurisdiction. So this is how the theory accounts for a plural society, like Canada, for example, where multiculturalism is widely important. And but it will account only to the extent that there are social structures strong enough to allow internalization. And it seems like a very abstract concept, but it isn't. In fact, empirically, if you look at what's happening, when somebody's claiming a value, like to be protected by a value that is not in line with the mainstream value of a society, they always belong to some kind of community that has a strong construct. So that has a strong presence in the construct of the society. So that's how I think I would link the possibility of internalization and internormative conflict in a plural society. I don't know if that answers your
Probably
question.
one example for such a value would be, what would be an example for one of those values?
You claim that I'll take the example of the keynote speech. You have to you want not to be obligated to stunt an animal before killing it. Then the question would be: is this value? Is this action just a random desire that you have for any reason, or is it actually a virtue that you've internalized? And that's where the legal court will have to wonder if it has in front of it a legal norm or just any random action of an individual. And if, I think in the case of like the Jewish or the Muslim community, there will be a very strong case for proving that it is in fact a virtue that has been internalized, and that therefore the social norm of not stunning an animal is a legal norm in nature.
You have a question? You first, and then. Oh, yeah. I have one question to all of you, and I'm wondering how each of you is going to, in his or her own context, going to give an answer to that. And the question would be: is law part of human nature? So I don't know who wants to start first.
According to whom? I think both Confucianists, at least the moderate part, as well as, of course, legalists, say that it's not necessarily part of human nature, but necessary for human society. For living together, for a society that functions, you need at least some kind of forced enforcement. And law, in a broader sense, if you also take in the principles of Li, of conduct, that of course that is part of the human nature according to Confucianist views. That a human is a social being, and this is part of them.
I would say that from the merely individual point of view, there's also something intrinsic in like if you want to perceive in the way an individual perceives itself, it has to have some kind of rule in order to formulate as being in time. When you think about yourself, regardless of what society you belong to, or even if you are in a society, when you think about yourself, you always formulate yourself in kind of an history, in a narrative, where your values and your characteristics are consistent in time. So in that way, I believe that rule making and legality is something that is intrinsic to to any individual, because you cannot have a unique personality, or you cannot have a unique perception of yourself without having some kinds of laws that are defining who you are. And I think that has a very that is based on a very strong phenomenological conception of how we feel we are.
I would say that, in the story, we would like to show and demonstrate law, but law and understood as norms, because we can differentiate between different types of rules. But if we understand law as rules imposed by authority, put it this very simple. So in this story, we try to tell human nature was a problem to address, I would say, by lawmakers and by law understood in this way. And I would say that what we are observing now is this shift to treating, actually this is the shift, treating human nature as less problematic, and as adjusting law, not in order to oppose nature, and not in order to contradict nature and natural drives, but just to fit into this. And I think this is the shift to we can observe nowadays about thinking about this relation between nature and law. Law should ideally, in order to be very effective, should actually imitate nature. this is the way in which people govern, like, in approaches to governing and policy making seems to be quite present. But what I wanted to say, no, I think no, I wanted to say something more, but I will come back maybe to a different aspect of this question.
One brief comment only. I mean, Kelsen, for instance, showed now that the reference to natural law is always a very thinly veiled power statement. No? So it's probably the last resort of a scoundrel, to paraphrase Oscar Wilde's famous saying about patriotism, natural law. But anyway, so thank you.
First question there.
My question relates directly to Magdalena and Franz, what maybe concerns Bettina and Hugo as well. I enjoyed your presentation and the new research direction very much for the reason because it made me uncomfortable. Uncomfortable for the reason that I felt that something is missing and that you have a set of assumptions which comes from a very Eurocentric and Western and positivist background. And there was one name which was missing from the presentation, which might broaden the view. It was the name of Hegel. And I wonder whether via Hegel you would push this a bit further away and step beyond the assumptions of positivism and enter the field of legal anthropology and let alone phenomenology, which I think would be less researched and, in my opinion, a very, very productive way into legal research in behavioral science.
Shall I try? Yeah. No, that was only the sketch, and we are very much aware of this, that this story is incomplete, and we are discussing all the time whom else to of course, like, actually this is, I think this is like a difference with Stephen's approach, who said that he's not interested in these broad pictures, but rather looking.
No, I'm interested in the picture, but questions like that always snag me. That's why questions like that,
no, but this is.
Go for it. I'm behind you.
No, but we of course in the story we had this discussion because I wanted to incorporate more Anglo-Saxon tradition, but simply but we didn't do this only because of the limitations of time and we are starting, so we just yeah. So that was absolutely agree with you. I would say that Hegel is, in a sense, on our side. If we understand his understanding of law is actually exactly creating this. For Hegel, nature was also a problem. So laws were actually this sphere which should have countervail nature as well. So in this sense, I would say he was in this German tradition, at least in respect to that, how he understood law, positive laws as and the rationale for positive laws as opposing laws of nature, as being alternative for laws of nature. So very quickly, my reaction to this. Yeah.
Yeah.
Yeah, of course, but.
I think that this would be most difficult and most productive for the reason that we don't have the methodology. If we approach human desires and human nature from a positivist point of view, we have a set of methodology. We know what to do. We know how psychological experiments work. Phenomenology would question the very assumptions about our methodologies. So this is a very grey area, but I think would be a revolutionary and a very radical way to understand human nature. It may be a dead end, but also it may be.
No, and there are very interesting, prompters regarding this kind of phenomenological approach in works of Waldenfels or Zangwill and people like this. But we didn't try to endorse a positivist view, which has tried to this was a kind of intellectual history approach, a contextual reconstruction in a certain sense. So we do not swear to any kind of to oath of allegiance to any kind of present day legal method, but it's a very welcome prompt. And what's also interesting, of course, we wanted to broaden the project in the future. So if our workshop turns out to be a success, we thought about it might also be interesting to look at other regions of the world and the connections between conceptualizations of norms and laws of nature in other world religions or other would be very, very fertile. We were quite afraid actually that our call for this workshop in May would elicit quite some contributions by Catholic natural lawyers, but luckily none of them applied. So, but we can see we can pursue this further in the future in different directions.
So we have time for one more question.
Oh, sorry, I was just a quick comment regarding the previous question about whether law is human nature, and I hope it doesn't sound too flippant, but I was going to point out that really, in the end, that it's crime and dispute that's human nature, and that if you go back, law really in the West begins because if you go back to early Germanic tribes, people were having disputes and beating each other up, and therefore law emerges because it's a more practical way of preventing the anarchy that was caused by these, I suppose, internecine disputes. And yeah, I suppose that there's, to get quite historical, there's a sort of very practical, fundamental origins of law that is perhaps not quite as represented by some of the theoretical discourse, which seems to take over in the sort of early modern period as well.
No, I think that Hobbes, speaking about theories, he thought about law exactly in the same way, so about the origins of law. And what I wanted to add is that in contemporary evolutionary psychology, we have attempts, like very, very strong and influential attempts to analyze and explain the origins of law exactly as resulting from the development of the human societies and so on. So this is, but we don't want to engage in not at all into the question about natural foundations of law and evolutionary origins of law. Just try to, like, our perspective today was to have a look at that, how different representations of nature are used in order to govern society. So this is the so are used by lawmakers, theorists, in order to inform about the content of the rules.
Last, very short question.
Very quick question for Hugo. Can the agent be mistaken about what is an internalized virtue?
You cannot. You cannot. Well, my proposition does not concern how the agent perceives itself, like as having internalized a value. It concerns how it's written from the point of view of the court. To see how a person internalize a value then is a question that is very difficult. That is, how do you know what's inside somebody else's mind? And the answer that will be the most coherent with that is to develop some kind of jurisprudence of virtue, of practical wisdom, where you start understanding what is it to be virtuous in a situation. And I think we started doing that with the reasonable person standard.
But that sounds almost by definition non-pluralistic.
It is formally non-pluralistic. So there's a form to law which is unique, I believe. But this form is I think universal. So in that sense, it isn't a problem in order to create a theory of pluralism. But substantively, I think this theory is widely is a fundamentally pluralistic, because it doesn't prescribe any content to the value that will be internalized. It just says there's a fact about human nature that we have to perceive ourselves in terms of laws, in terms of narratives, and this is the form of legality, and this is the jurisdiction of the legal scholar and of the legal thinker, and this is what we're studying. But instead, except that, there is like no single value that's supposed to fit in this form.
So, time is up, and I would like to thank our great presenters and all of you for this very inspiring discussion and questions. So.